morning, everyone. Good afternoon, actually, it is now, isn't it? Yeah. Good afternoon, everyone. Thank you for coming along to our latest One Chancery Lane webinar. You'll see that today I am joined and delighted to be joined by José María Pimentel, who is a Spanish lawyer and partner at DAC Madrid. Just been asked, is the second session recorded? Yes, it is recorded. You will get a link to the recording at the end. But bear that in mind if you're asking questions. If you would rather remain anonymous, absolutely no problem at all. Just anonymize yourself for the Q&A. Otherwise, we're all friends here. We've all asked loads of questions, some of them sensible, some of them not massively sensible. And that is no problem whatsoever. We'll answer any questions that you may have as we go through. But as I say, we are being recorded and the link will be made available to you afterwards and to everyone who's registered afterwards. And it will also go up on our YouTube channel along with all the other webinars. So as I say, I'm joined by José María Pimentel, who is a very well-known, very well-regarded expert in Spanish law, as well as being a partner, as I say, in DAC Beachcroft, Madrid. I don't think we've ever been on the same sides in a case, but we've been against each other a number of times. And I think the reason we've never been on the same side in a case is that usually the defendant gets to you first, José María, which means that they can flict you out and I can't have you as my expert. But one day we will work together as opposed to opposite each other, I'm sure. We're going to deal today with how to get the most out of your expert. And José María brings his unique perspective to this because he both instructs experts and is instructed as an expert to tell the English courts what Spanish law is, both in relation to liability and quantum in our cases. So we're just going to have a quick run through. It's going to be the same format as it always is with our webinars, which is kind of organized chaos. We're just going to go through the slides saying the things that we thought might be useful for you. As we go along, if you violently disagree with something that we've said, or if you've got a story to tell, or if you've got a question to ask about a case that you've got, then please do ask on the Q&A. If you talk to us on the chat, we might miss your question because we think you're just chatting with your friends. But so if you ask on the Q&A, we will know to answer as we go through, and there will be some time for questions at the end. If you ask a question in the chat, we will try and get to it, but somebody always does, and that's fine. We've had a lot of questions beforehand, so we're going to try and answer those as we go through. If you feel that your question hasn't been answered, or you meant to ask something different, or we've just misunderstood, then please reiterate your question as we get to the end, and we'll go through it. There's lots to get through today. We actually asked our colleagues to give us some help with how to get the most out of your expert, how to instruct experts, what to do when you don't agree with them, conferences, joint statements, that kind of thing. And we had loads and loads of really helpful responses from our colleagues. This seems to be something that people feel they have a lot to share with. People have got a lot of war stories about experts and things going wrong, things going right, what people wish they had done differently. So we would really like to hear from you on yours. So just to start with, how to choose your experts. Really the fundamental building block here. How are you going to choose your expert? I know lots and lots of firms just always use the same expert they've always used. And so you'll always see the same people giving evidence in various areas of expertise. One thing to do is just to keep on using the expert you always use, and that there's nothing wrong with that because you know that they work in the way that you want them to. You know that they're well qualified. You know that they deal with things in the way that you've kind of trained them to deal with things. But have they retired from practice? One of the big problems that we have with experts is that because we've been using them for a really long time, they might have retired. And sometimes in cross-examination, you see people say, well, you know, when did you last actually see someone with an injury of this nature? And the expert will say, well, I haven't been in practice for 15 years. That's fine, depending on what area of expertise you're talking about. They need to keep up to date. So you need to ask them how they keep up to date. And do they think, is it a problem that they no longer see people in practice? You also have some experts who only ever do medico-legal work. They don't actually do clinical practice at all. That again is a problem. Someone like José María, for example, if he were to retire from the law, within quite a short period of time, he'd become a really dangerous expert to use. I hope you don't mind me saying, as indeed would I, because we can't keep up to date on what is happening. So using the same expert you always use is quite a good idea in terms of that you know their experience, you know you can work with them, but at the same time, you need to be sure that they're keeping up to date if they've retired. Another method, following the recommendation of a colleague. Now you need to be clear as to what the colleague is saying about the expert. Are they a good expert generally, or are they a good expert for use in your type of case? So following the recommendation of a colleague can also be useful. And then again, the third bullet point that we've put there, an experienced medico-legal expert or an experienced practical expert. Do you want someone who's actually a practitioner, or do you want someone who does lots of research on something? So that can not always be the same thing, but that depends on the type of case that you've got. Jose Maria, what do you think? How would you choose an expert?
Well, first of all, thank you for inviting me to this chat, and good morning, buenos dias to everyone. It's a big pleasure to be here. Sarah and I have been generally we have been just in front, so the first conclusion is that you can get it very well with your competitors and with the counterparty. So this is the first recommendation I'm giving you. I have 3 comments on this one. You can have a very good panel expert, what I call a legal. You can have a legal expert who is a very good general practitioner, but perhaps you should need a brain surgeon for a specific case. And obviously, the first source of information would be your usual expert, and your usual expert should be honest enough so as to recommend you to the most appropriate expert, which is difficult because I understand that instructions do not come very often, but we need to be honest when being clear with our clients, saying this is not my expertise, you should go to this expert. This is the first comment. The second one, talking about expertise. Obviously, expertise is very important, but sometimes we will need or we will have to rely on younger or less known options. So there is nothing wrong in trying a younger solicitor. There is nothing wrong in trying a solicitor who is not in a directory, but you know that he or she is very good. So don't be afraid or changing from time to time. And the third question, this is a message for barristers and solicitors. It is for you guys to analyze where the match is going to be played and choosing your expert accordingly. Because sometimes your common expert or your usual expert would not be perhaps the best for dealing with certain areas of law, whereas a very, very technical expert would not be best placed to be cross-examining a county court with limited time or with adverse circumstances. So this are the third, my first comments on this one. We would talk a lot about the skills that an expert should have, in my opinion, but this would be in the next slides.
Okay, let's move to those then. Yeah, I mean, you mentioned Jose Maria, directories, and I think we probably both have the same approach to directories, which is that the directories are not always necessarily going to give you the answer to this. I think you're much better to have a personal recommendation or personal view on it and tailor the expert to the case that you're looking at. Whereas directories can't do that. I think you're quite keen on saying, well, what is this particular case? What is the issue in this case? And is that something that this particular expert is good at? And directories don't really help with that, I think. So I agree with you about that. I don't think directories are enormously helpful here, although they do reassure the client that you've got the right person. In relation to agencies as well, with a very standard case, if you entrust your choice of expert to agencies, they may be useful. But in any case where there's going to be difficulty or where you think it's going to be controversial, that's probably not good enough, honestly, to be perfectly honest. And then somebody in chambers actually said, what about similar cases? So sometimes you can think to yourself, well, I saw a case on Westlaw or Lawtel or one of the reporting agencies that's very similar to this case. So the leading case in this is X versus Y. And then maybe use the same experts as somebody else used in that case, the reported case. Two issues about that. Just because someone's been in the case doesn't mean that they were necessarily a good expert. And secondly, they might have a personal interest. So they might have an axe to grind. They might regard this as being something that is their own personal hobby horse, and you need to just be a bit careful about that. But I think that's quite helpful. If all else fails, I look at other cases. So we often ask for foreign law reports from foreign jurisdictions, and some jurisdictions I haven't dealt with very much before. So for example, I don't know, I don't think I've ever had a Russian law report. And I might go and look at cases involving similar issues involving Russian law and just have a look at what the judge has said in their judgment about the experts the party used. Now that can be unfair because sometimes judges are unfair on experts in judgments. Both, you know, they both talk them up and talk them down, but it is a starting point, I think. And then something that somebody else said in chambers that I thought was just encapsulated this choosing aspect. A thoughtful, balanced and fair expert will always be a better choice than a blinkered, bullish expert who will tell you what you want to hear and then collapse in the witness box. And we have all seen that. Experts who produce reports that are just what they think you want, and you rely on those reports, you get to court and you get to cross-examination and they just crumble in front of your eyes. Now, I would rather know at the beginning of a case that I've got no case than find out when I've spent £100,000 worth of costs. And I think that is a really important point. And Jose Maria, you were saying, you know, you need to be honest enough to recognize your own limitations, but also honest enough to stand up to the people instructing you, I think.
Yeah, I think you are right. I think directories, I mean, directories are good, for example. I think that for me, the personal knowledge of the expert is the fundamental tool to recommend a client or to instruct an expert. A recommendation from a client or recommendation from another colleague is also essential. I don't have any obstacle in recommending a good lawyer for dealing with a personal injury claim as claimant. So I think we as lawyers have an obligation of providing all the parties with the best advice possible and to recommend the parties a reliable solicitor. I mean, it's something normal. So directories are good when you have, for example, a case, I don't know, in Dubai, and obviously you generally don't have cases there, and you don't have any feedback from colleagues and etc. You can find obviously in the most famous or popular directories. Then you will probably have the extra job of educating the expert on how to produce a compliant report and etc. But are good for that. And apart from the what is the personal knowledge of the expert, there is another source for choosing an expert, in my opinion, who is I have chosen so many experts that I knew or I met when working or when working against them. So I was impressed about the quality of certain expert during a cross-examination or whilst reading a report. He was shared with me because I was the other party expert. So it's not just the personal knowledge or the personal feedback, but rather also the experience you have with another expert, and then you realize that there are experts that are probably better than you, or experts that probably are dealing or are coping better with different areas of the law. So I've never ruled out any expert because he or she does just claimant work. In fact, if I see that the expert is quite good, I always try to take him or her to the dark side of the force, and just for him or for her to prepare defendant work. Sometimes it works, sometimes it doesn't. But this is another and a very important part of a very important tool or for you to have a wider list of potential experts to instruct.
Sure, and that's a great point. Absolutely. Sometimes, and I actually give a number of references for the directories for people I've been against, because sometimes you're against people and you just think, this person is just really, really good. And there's no reason why you shouldn't use them as an expert if they're good. We've been asked a question. Any tips for challenging a court-appointed joint expert who you suspect does not have the relevant experience and also you think is showing bias? Well, if they're two slightly different things, but of course you should challenge it, make an application and put in a witness statement that says, well, this is what's happened. This person was appointed as a joint expert, but this is what's gone wrong. And this is their CV and this is what they're being asked to do. And actually they can't do it. And if you think they're showing bias, then I'm afraid you have to say that and say, look, something has gone wrong. And the expert looks as if they're not actually independent. And that gives an impression to the client, whether claimant or defendant, gives an impression to the client that actually they're not independent. And that means that there's an impression that justice isn't being done. So I think I would frame it in that term, as opposed to this is a total hack and hatchet man. And it's all going wrong. It's more, there's an impression that actually they're not going to give an unbiased report. And I think the courts are quite open to that if you can substantiate it, but it does need to be substantiated if you're alleging bias. And we've covered this a little bit, which is choosing the expert to match the case. What's your strategy? What are you looking for them to do? Can they do it? Can they do it in the time and for the price you need them to do it? And how long is it going to take them to do it? So because we've got such a big backlog, certainly in this country, with COVID, it's taking 6 months to instruct a psychiatrist. Well, the courts are saying you're just going to have to instruct a different psychiatrist because 6 months is way, way too long. Whereas pain experts are quite few and far between. So the courts are sort of happier with a very long lead time on that. But if it's generally speaking, if your expert's a good expert, they are going to have a long waiting list. And you do need to tackle that and get yourself on the waiting list almost before you've got permission to get that report. We had a discussion, Jose Maria, about style. Is it better to have a simple, straightforward style, or do you think courts are more impressed by a technical language and very kind of involved technical style? I mean, I know I have a preference, but do you?
Well, I think the perfect example of that you cannot be the most technical lawyer is me, and I think you need to know your limitations. And I've read so many reports on Spanish law issued by the most prestigious academics in this country that did nothing to do with the case and that were done were fantastic, but were done in a very Spanish style, which means that never-ending paragraphs, quotes of never-ending case law with no relation with the case. So it's not a critic, but it is my recommendation to barrister and instructing solicitor is that there is nothing wrong or bad in polishing the style of your instructing solicitor. And if the instructed solicitor is reluctant to change his or her style, perhaps he or she is not doing his job appropriately, because we are not here to see or to confirm how good we are, how nice we are, how well we write a foreign language. We are here to help the court and to help the parties to defend their position. So there is nothing wrong in polishing in fact, I've been polished so many times that there is nothing wrong. And in fact, this is the best way of learning and to making your job better. And our obligation as solicitors is to do our job as best as possible. So nothing wrong in doing that. So be clear with your expert when you see that the report is done by using their own script, by using their own style because they think they are writing a report for the Spanish jurisdiction, for example, or for the French jurisdiction, etc. So that's the first thing. And just to finish with the style, I think an expert acting in a foreign jurisdiction should be should have the ability of explaining the legal issue or explaining the legal issues in a clear way. I'm not talking about using slang. I'm not talking about talking with disrespect to the judge. I'm just talking about using normal language of the 21st century. And we as lawyers should have the ability of explaining things in a normal way, in a plain way, because the judge is not familiar with our law, and the judge does not need a pedantic expert explaining things like if we were in the 16th century. The expert should be clear. The expert should use an appropriate language and has to support that comments or that conclusion by using references to case law and to doctrine. That's what, in my opinion, is or should be a good expert, and that should be the style that an expert should have to comply with his or with her duties as expert on a foreign law.
Yeah, I agree. I mean, I think it's always, you've got to ask yourself, at the end of the day, you're preparing as if you were going to trial, and you need a report that a judge is able to understand very quickly, because we live these cases, they go on for years, but a judge has got maybe half a day's reading time. What the last thing he needs is 100-page reports, all written in very technical language. So if you've got an expert who is doing that and producing reports that are very hard to understand, very dense, that's harder to read. It's more exhausting to read for a judge, and judges prefer things to be straightforward, and most things can be made straightforward. And very good experts, the best experts, make everything look easy. The worst experts make everything look difficult and look as if it's hard for us to understand it. But I was talking to someone who was talking about cryptocurrency the other day, and she explained it to me in a way that was really simple and straightforward, and I understood it really well. And the reason she was able to do that is because she knows what she's doing. She's so good, she can explain it even to a dunce like me. And that is what you want in your experts. Now, we were asked about challenging fee quotes. I think the only way you can do that is by saying, this is a, £25,000 claim. I'm not spending £25,000 on an expert report. If an expert comes back and says to you, it's going to take me 10 hours, and you think it's only going to take 2, then you say to the expert, well, look, there's only 100 pages of documents. It really shouldn't take you that long. But what you can't do is to force an expert to do your report for a very low fee when the expert says that it would take a very high fee to produce a good report. So you're going to have to go to a different expert if you want a lower fee quote for that. But I think that you should be getting fee quotes on the basis of, we think it's going to take you this long, and we know there are 400 pages of documents or whatever it is, but you don't need to look at them all. So you ought not to be having to challenge fee quotes if you have told the experts the appropriate information on which they quote. So I hope that answers the question. I'm not sure it does.
Yeah, well, and in fact, fee quotes are now asked by all clients. So it's not like in the past where we work on an hourly basis and no one challenged the barrister or the expert fees. So now there's a new reality. Talking about new realities, fee quotes are very normal now, and there's nothing wrong again in asking your expert to provide you with a fee quote.
Oh yeah, of course.
What is a mistake is not asking him for a fee quote, because otherwise he or she will understand that he or she is entitled to apply hourly rates, but being clear again with your expert, saying, well, this is not the case of your life. This will take you 5 hours. Would you mind to provide me with a reasonable fee estimate? And that shouldn't be a problem. But always our solicitors and the client should ask for the fee quotes. Fee quotes can change, can vary because of certain circumstances, but it is a fundamental part of our job as an instructing solicitors to ask the expert for a fee quote. Otherwise, you will have surprise at the end of the case.
Yeah, exactly. I mean, you should be getting a quote for everything that's done before it's done. In terms of when to brief your expert, you've got choices. if you do it very early, you conflict your expert. And I know that that's something that Chris Deacon was talking about in relation to barristers. I actually don't like that at all. But there's no denying it's a good strategic move. That if you instruct your expert very early on, then he's going to be conflicted, or she is going to be conflicted and won't be able to work for the other side later, which actually is something that I might start doing with you, Jose Maria, start conflicting you out in all my cases. So you can do that. And that also helps because it informs your litigation strategy. You get your expert on board early. The bad thing about that is that your expert doesn't have all the information at that point. So it means you're going to need to go back to them for another report later. The other choice is post-investigation and pre-litigation, which means that there is more information and the expert then helps you with what more you could expect to have. So it helps with the information gathering and does steer the strategy. And that would be my preference because I think this is it's like the best of both worlds at this point. Whereas if you wait until post-litigation, the issues are clearer, you've got all the information, but the best expert might already have been nabbed by the other side. And your expert is not helping you with strategy in that case either. So I think experts can really have a good input into strategy. And if you wait until after you litigate, you're already going down a certain route and they don't have a chance to help you with that.
Well, I think that the PreLead phase is the best one, if possible. I know that there are clients that prefer not to invest money on this phase. But I'm not just talking about a report, a comprehensive report on quantum, or I'm just asking your expert if you have any doubt, or just to ask the expert of provide you with any idea on merits or quantum, because by having a preliminary report, not perhaps by your expert directly, but perhaps by another expert, by another solicitor, you can take a decision and save money, because perhaps the experts say, well, listen, with this documentation, I think you don't have a case, or with this documentation, it is worth to get 2,000 euros for this case. Yeah. It's better not to litigate. Perhaps this persuades the other party to begin with settlement talks. I don't know, but the PreLead is a very good money invested at the beginning rather than at the end, because post-litigation you have now the fight initiated, so the attitude of the parties towards a negotiation would be lower or less intense than in the PreLead phase. So why not in the PreLead phase and just trying to get a clear idea of merits and the future of the case.
I agree. We've had a comment on fees. So just going back to fees for a moment, expert fees are often reduced on assessment, and almost always the expert refuses to reduce their fees or accept a shortfall. I wish barristers did. So why do the courts reduce disbursements on assessment knowing you can't challenge the expert fees? What can you do if fees are reduced? I don't know why the courts do that, honestly. I think some judges have an unrealistic view as to what experts' fees ought to be. And I think some judges have an unrealistic view about whether or not you're going to be able to persuade your expert to accept a shortfall. But I'm afraid that if you've agreed a quote and if the expert has done the work, then that shortfall is going to have to come out of the other costs because you owe the expert the money because they've done the work. And actually, there is a sense in which the client is getting a service from the expert and they ought to pay for it. So there is a sense in which, in most other jurisdictions, clients would have to pay the costs of the expert and wouldn't be able to get them back. So I'm afraid you just have to swallow the shortfall. But I don't know why judges do it. I don't know why they do that, but I know that they do.
Well, the only way would be to create a sort of fees guidance for expert on foreign law, but I guess you have enough issues with your fixed fees regimes and etc. Because here we have a fixed guidance, but obviously it doesn't cover reports issued for foreign claims and etc. So the only way of trying to, in my opinion, to reduce the expert fees, talking about the legal fees, obviously, is perhaps by negotiating, because you will have another expert who can tell you, well, this is perhaps so high, this is so low, this is reasonable, etc. So at this point in time, in my opinion, is the only way to just try to diminish this is by negotiating with the other party in the same way you do with solicitor cost.
Yeah. Yeah, but I mean, that's something that you should be doing at fee quote point with the experts. Okay, moving on. So what to tell your expert, instructions, clear, concise and impartial. And enclosures, the same thing, include all available relevant information. I can't believe I'm having to say this, but this came up again and again and again, that people only provide experts with the documents that go to help their case, as if you don't give the expert documents that are disadvantageous to them, that's going to be okay. It's not going to be okay. It's actually going to create problems for the future, because if you only give your expert your side of the story, your expert is going to produce a report that is advantageous to you, but is not based on all the information. So you think you've got a great case and you carry on with it. And then suddenly, when the other side start asking questions, or when your expert meets the other side's expert, they're going to realize that the case isn't what they thought it was. And not only are they then going to look really silly, but they're going to know they look really silly, and they're going to be very, very cross. So give your experts, and this is true of barristers as well, give us all the information that is relevant, not just the stuff that goes in your favor. And quite often that happens to me, that people send me only the documents that help my case and ask me to advise. I can't advise meaningfully if I don't have the defendant's case and the defendant's documents. And the other thing is, as you all know, is a perennial bugbear of mine, which is that if you give people documents in an easy to navigate format, then they might read them. If you give them 100 links to numbered rather than named documents, they might read them. They might not read them. They might try and read them all, but not see all of them. So I think simple, straightforward, and give the expert everything.
Can I add something on this, Sarah? I have some notes here, and I have something writing, which is rather and thinking on the accuracy of the instruction. What does this mean? That one of my most favorite word in English is the word candid. So you guys need to be candid with your experts and explain very well the purpose of the instruction. I totally agree with you in the ways in which the documents are presented, and on the obligation that our solicitors and our clients have to provide us with all the documentation, even the one detracting our position or detracting their position. Sorry. But if we are not clear in providing instructions, you can have an unpleasant surprise. And I will tell you one history. I'm a history teller, as you know, a very quick one. When I joined DAC a number of years ago, TV were black and white probably now. Well, I was asked to help one of our London partners to prepare a case with a Spanish component. I was asked to complete the defense that was going to be served in the UK. I had to deal with the non-contractual liability side in accordance to Spanish law. And the instructions were, please prepare a defense. And it's what I did. But obviously I did it in the way I do in Spain, which is never-ending paragraphs, quoting case law, etc. And it was I'm not exaggerating, probably 20 pages of defense just dealing with non-contractual liability. I sent that to the partner, and I thought, well, today is my last day as junior. Tomorrow I will be promoted as partner. I mean, I didn't know I was so good by practicing law. I'm going to be promoted, sent to London. I will be the managing partner there. Well, the feedback was not particularly positive, because obviously this was not what the partner expected. She expected a proper defense, or a proper structured defense in an English way. So why I'm telling you this history? Because if we are not clear and we are not concise, we can have this type of surprises. And as we are never plenty of time to react when we have these surprises, we need to be very candid with the expert. There is nothing wrong in being candid with us, but please make sure you are giving the instructions in a proper way, because otherwise you will have an unpleasant surprise, and majority of times you will not have enough time or all the time you want to solve or to jump the obstacle.
Yeah, I mean, tell your expert what you want.
Yep.
Tell them what you want. We've had a question. So if the opposing party wishes to adduce inadmissible documents or documents where the admissibility is contested, what is the best approach for instructing your expert? Should you present them with the potentially prejudicial and inadmissible documents? No. No, and neither should your opponent be doing that. So where you have contested documents, you need to sort that out before anything else happens. So everything stops at that point, and you go to the court, you get a ruling on admissibility, and then you go back and instruct your experts, and both sides do that. So if you have documents that are contested, you don't show them to your expert. Where the other side has documents that are contested, you send them a letter saying don't show them to your expert, because if you do, then you run the risk that we're going to knock your expert out, because if those documents are inadmissible, then so will the expert's report be, and you'll have to start instructing a new expert and you have to start all over again. So sort out admissibility first and then worry about the experts. So experts being impartial with a duty to the court and not those instructing them. What about instructions which might be considered leading, including amendments, for example? Where's the line? Yeah, we talk about amending reports a little bit later on, but the answer to that is instructions can be leading, but it's better if they aren't, because don't forget, the court wants to see an independent, unbiased report from an expert. If you are producing a hatchet job from someone that you've told them what to say, the court is going to immediately be less impressed by that than it will be by the other side's reports. And in terms of amendments, we'll talk about that a little bit later on. So let's move on to amendments. Oh, before we do that, what to tell your expert. As part of the instructions, some of your experts will want to know the relevant legal tests. So in terms of, if I'm instructing José María, he needs to know whether I want a local standards report or whether I want a local law report. And that's quite important. So in our area, so package holiday claims and cross-border disputes, in cross-border disputes, I'm going to ask him for a Spanish law report, which will include things like who bears the burden of proof, what is the standard of proof, what is the limitation periods. In a package travel case, I'm going to ask him for a local standards report, which is local regulations, local custom and practice, but English, burden and standard of proof and limitation will apply. So if I ask him for a Spanish law report in a package case, I'm going to get the wrong report. So I need to tell him what it is that he needs to give me. In medical experts, they're going to need to know the Bolo and Bolitho test if they haven't done reports before. They're going to need to know the Montgomery tests in relation to consent, and they're going to need to know the but-for test in relation to causation attribution. That is, of course, for experts who haven't done a lot of experts reports before, but it is worth putting the legal tests in to your instructions so that your expert knows exactly what it is that you want from them. It's all about, as we've been saying, what do you want from your expert? Work out what you want and then ask the expert for it. So that's helpful. Now, in relation to the contents of the report, and I promise I will get to the amendment point in just a minute, the report shouldn't usurp the function of the judge or advocate, which was something that José María was saying earlier, that the expert isn't giving you a piece of advocacy in favour of the client, and they're not giving you a judgment either. They're giving you an independent, unbiased view on the issues on which they have been asked to opine. So if I ask José María, for example, for a Spanish standards report, and he gives me a whole load of stuff about burden and standard of proof in Spain, he's giving me something I don't want and haven't asked for. And all of that has to be redacted. So we need to be really clear on what we're asking for, and the expert needs to be listening and giving us what it is that we're asking for. Importantly, and in support of that, the report has to set out a range of opinion and why the experts fall on some part of the range. So you sometimes get in Spanish law reports, well, there's a range of quantum outcomes. And I think it's towards the bottom end or the top end or the middle end of that range. And the reason I think that is that this is not the most serious injury I've ever seen, or it is the most serious injury I've ever seen. And I mean, I'm sorry to say, actually, Jose Maria, that you get a lot of Spanish law reports which say it's up to 80,000 euros. So I'm going to say it's worth 80,000 euros. And that's actually really unhelpful to the courts, because they say, well, why is it not no euros, which is right at the other end of the range? I need to know why it is that you think it's up at the top of the range. In nothing I say am I implying that you would do that, because I know that you don't. And so I've seen your reports where you say, well, I think it's 25,000 euros and this is why. You know, there's a very similar case, or it's towards the bottom end of the seriousness of the injury, or whatever it might be. But that is how the report should be structured. This is the range. This is why I think it comes here in the range.
I have to confess that I'm guilty of trying to act as a judge or as an advocate when it's
You're not. You're really not. I
am, but this is obviously we do advocacy. We tend to provide our clients with advice, and I mean my recommendation is just a beg for my instructing or future instructing lawyers and barristers. Please repeat me or repeat all the instructing solicitor what their role is, because otherwise you will find with so many conclusions in our report saying, in my opinion, the defendant is not, well, in all my reports I try to say that, obviously, but in my opinion, the defendant is not liable for this, and this is not our role. And I remember in a case where the solicitor told me, the report is fantastic, but you are not here to reach any conclusion. So please remove this, and I really appreciate that, because again, we are here to comply with our role, not to feel better with ourselves. But sometimes this is not a critic; is something that I experience in a case. Sometimes it's good to listen to the expert, not. I mean, obviously, listen to the expert in the way or in the report he or she is doing. But sometimes in those meetings, we have to prepare the case or just to prepare the trial, or well. I remember a case where I was there just to give my opinion on Spanish law and quantum, and I was in the meeting and they were discussing about jurisdiction and applicable law. It was a Rome 2 case, and the barrister was giving his opinion, and the opinion was right. But there was another option of construing Rome 2 at the time, and I simply say, well, sorry, it's not my role. I do apologize for interrupting you, blah blah blah. But have you considered the option or the possibility of going further under Article X of Rome 2? And well, he noted my comment. I probably ignored me, and well, I produced my report on quantum, and I was convoked to a presidential meeting in London 1 year after, and my instructing solicitor told me, you need to be here, and I thought, well, this is very strange, because we can have a conference call or what. Well, I was there. The room was full of people I didn't know, and it was a new barrister, and the client told me, we have been discussing about this, and we read the memo of the last meeting we had, or you had, and we have realized that you raised your concern about the strategy given, and we have realized that this should have been done in the way you suggested. Obviously, that was not my intention, but sometimes we have good ideas. Sometimes, so sometimes we are very intrusive about the way in which things should be done, but sometimes we have some expertise on jurisdiction, we have some expertise on applicable law. We know the expert of the other party. Well, this type of thing should be considered. But please do not hesitate to tell your expert what his or her role is, because otherwise he will try to go further and further, and will try to provide you with his recommended course of action. So apologize on behalf of all the experts instructed on. Yeah.
It's a two-way street, right? It's, we talk to each other. And this is, this also feeds into, what do you do if the report isn't what you wanted it to be? talk to your experts. You know, if the report's not CPR compliant, that's your fault because you didn't tell them how to make it CPR compliant. If the expert is doing what a judge's role is, that's your fault because you didn't tell them in the instructions not to do that. If the report is factually wrong, either you haven't made it clear in your instructions or the expert hasn't read the instructions. Tell the expert, look, I don't think that you've read this properly. Could you just take another look? I'm sorry, I don't think you've read the medical reports, the medical records rather properly. Could you just take another look? If the conclusion is not favourable to the client, you can't tell them what to say. So if you don't have a case, you don't have a case. And you're better to know that now than to know it later. But where there's something wrong with the report and it's not accurate, go back, tell your expert, you know, I think maybe you've just missed something, or I didn't make something clear enough. You know, and let's talk about this. And it's not uncommon for experts not to realize they don't have everything they need or should have. So you need to check that they have got what they need. So, for example, so often you see it in court that in a report, the expert hasn't made any reference to a pre-existing relevant medical condition, or hasn't made any reference to previous accidents. That report should never have been disclosed to the other side because somebody should have picked it up first and should have asked the expert, well, okay, you've said in your report they don't have any relevant pre-existing condition, but did you see the GP's reports or GP's records from 10 years previously? Because it looks very much as if they do. Can you just put something in about that? And does it change your view? And it may change their view completely, but as I've said previously, you can't cover that up. The other side are going to notice that and they're going to ask your expert about it. And you are better to future-proof your report by raising it now and having the report change so that the expert has everything they need before they report.
Otherwise, we will be in a very tense situation when we are in box. I mean, here, 2 comments, just very, very quick comments. For solicitors organizing the documentation, please take your time to prepare the documentation and do it in a good way. I mean, do it in the same way as you expected to receive the documentation from the other party. That's a matter of courtesy, and that will facilitate the life of the other party and of the expert. And the expert evidence will be probably your strongest evidence. So do it in a proper way, no matter about units, no matter about time spent, no matter about efficiency. This is a very important part of the job, because if you don't provide the expert with all the documentation and then the other barrister asks the expert in the box about this, you will place your expert in a very difficult situation. And believe me, that when you are in the box, you feel a little bit nervous. And this is said by a lawyer who has passed probably 500 trials in Spain, and the level of tension in the box is not the same as if you were in a court in Spain. And for experts or for future or potential experts on any foreign law, take your time to consider the documentation you receive. Don't wait for the night before the deadline to realize that you don't have all the documents, because you don't have time to react. And well, we tend to wait until the last minute. We are lawyers, and I'm guilty of doing that as well. But take your time. This is a very serious thing. This is a report who is going to be who's going to help a judge to take a serious decision. This is a part of the job that has been entrusted by someone who trusts you very much. So you need to take your time. This is not a last-minute volume report. This is a very serious report, and these reports are done by very limited experts. So you need to feel proud of the instructions, and you need to act consequently on that, obviously.
I agree. So Simon Balls asked, is expressing an opinion on how much the court should award for, let's say, pain and suffering, something for the experts? So if you say, well, I think it's, you know, pain, suffering, loss of immunity is worth 25,000 euros for moral damages, should he or she simply be giving a range and pointing the judge in the right direction for making their decision, or can you give an actual award? It depends on what jurisdiction you're in. So if you're in Baremo Odontiac territory, then those are tables which will give you quite a small range. So that's going to give you quite a small range. But in other jurisdictions, so in Greece, for example, you might get a much bigger range. So it kind of depends on the jurisdiction, I think. But where there is a range, the expert should always give it, and then say why they think it comes down to some part of the range. So range plus this is where I think it is and why. Now, 2 cautionary tales next in relation to breaches. So breaches of the CPR should be resolved. And in this case, Dana UK, the defence technical expert's report was chucked out completely because the report breached the CPR. That should never, ever happen to you, because you will always ensure that the report is CPR Part 35 compliant before you start. It'll be in your instructions, and when you get the report, you'll ask the expert to alter it if it's not compliant. You will never, ever be serving a report like that, still less going to court, going to trial with it, because that is a disaster. So second, really scary case, and this is to do with amendment, don't tell the expert what to say. This is the Zafar case where the Dr. Zafar, the GP, was sentenced to prison, suspended, for contempt of court, because he made it more favourable to the claimant at the request of his solicitors. So his solicitors had said, can you make the reports work better for us? And he said, yeah, of course I can, and changed it without seeing the claimant again. And the court said in that case, the starting point where an expert does that is a custodial sentence. Don't ask your expert to do that, because you're asking him to risk going to prison. And if you're an expert, don't do it, because you are risking going to prison. It should go without saying that you don't tell the expert what to say. They tell you what their opinion is. So moving on from those slightly terrifying cases, where you have difficulties, just talk to your expert. There might be a reason as to why you've got a difficulty. Pick up the phone to them. There may be a language problem. We've had that so many times. Foreign language, the expert thinks that they speak very good English, or you think that you speak very good French, but actually you're just not talking to each other in the same language, literally. Technical language can cause a problem. You're talking about 2 different things. Sometimes you've instructed an expert in the wrong area of expertise. The expert doesn't know what it is that you want to know from them, but they try their best to tell you. And this is an expert who's not confident enough to say, as José María has said, actually, you don't want me, you want someone else. And this always reminds me of that cab driver who ended up on Channel 4 News being interviewed because somebody saw him hanging around in the lobby of the news station and said, you must be the expert. And he just sort of ended up on national telly being an expert in something, because he didn't like to say, well, actually, I'm just a cab driver, I'm waiting for someone. So make sure that you're talking to an expert who knows what you want and understands what's required, and that you understand the expert as well, and that will solve difficulties. Now, in relation to Part 35 questions, we asked quite a lot of questions about this.
Sarah, can I add something about difficulties with experts? Sorry, I have quite a few comments here, because there's an expression which says, with the age come the wisdom. So this is based all on true histories. I would say talk and listen to your expert, as you have said. So at the end of the day, we are legal professionals, so we are very good by listening ourselves, but sometimes we are not that good by listening to others. So make sure the expert make sure you apply a bi-directional flow of communication with the expert, and just to make sure what the problem is, because perhaps the expert is not able to explain in a proper way the concept, because we are using a second language. We don't use the language in the same way as we use, in my case, Spanish. So you need to understand the why of things, and that's very, very important. And make sure the expert understands all what you are saying. And if you have any doubt, and if you feel embarrassed about telling the expert, well, your English is not as good as I thought, do what I did when I had a conference call with my first clients when I joined the AC a number of years ago. I was not very confident about listening and having a conversation in English for obvious reasons. what I did was, could you please send me a note with the instructions just to make sure I have not missed anything? This is my recommendation for you guys. If you have any doubt on whether the expert have about all the instructions, just send an email with the bullet points or with instructions. That will facilitate things. And the last comment, if for any reason you are going to you decide to use a translator, just for the legal expert, for the medical expert, or for any other expert, make sure the translator is good. Yeah. Invest money in a good translator, because otherwise you will be in difficulties. There are very good translators, obviously, but I was in a case where I was not acting as expert. I was acting as a hotel. Well, they were using my facilities for a cross-examination, and they need a lawyer there, and I was there. But I noticed that during the cross-examination, the translation was really bad. I was not a part in the proceedings. I was just facilitating the venue for the video link. So don't ask me why, but I was brave enough so as to interrupt the cross-examination and say, well, Your Honor, sorry, my name is José María Pimentel. I'm not a party of this one, but with all the due respect, I think the translation is not good, and I'm not bilingual at all. But I offer myself to continue with the interpretation. And I could see how the camera moved just to focus on the judge. And I thought, why you have done this? I mean, you were so quiet listening, and the judge asked me, please continue. So I did all the translation into English. I spent 3 hours of my life by just trying to, I was exhausted. But obviously this happened because the judge decided that it was the most flexible way. But sometimes you will not have a good or a flexible judge, and the judge can put you in difficulties with a party who does not speak English and perhaps cannot accept that statement or that cross-examination. So cheap can be costly. So please invest money on your translators, because otherwise, believe me, you will have serious problems.
For sure. I really echo that massively. Yeah. I mean, we've had in chambers a number of trials had to be adjourned because the translations were just not up to it. So interpreters really important, particularly at trial, but also at other stages, as you say, in report stage. So part 35 questions, get your expert involved. I don't know what questions to ask the other side unless my expert tells me where the holes are in their reports. Do you really need to ask them? Only ever do anything you really need to do. And that goes for part 18 questions and part 35 questions. If you do ask questions, sometimes the expert comes back and says, well, I'm glad you asked me that, because actually I'm right for lots of other reasons as well. And all you're doing is plugging the gaps in the other side's case. Similarly, the other side may ask your questions, your expert questions, which plug gaps in your case, which is great. Are they appropriate though? Don't necessarily just allow your expert to answer questions from the other side, because they may not be appropriate within part 35. But generally speaking, I have enough confidence in my experts that I let them just get on with it and answer questions, but consider them a little bit. Is it worth asking questions? And if it is, get your expert involved and get their opinion on what you should be asking. Now, in relation to joint discussions, lots of people actually asked, should we provide an agenda? That's obviously something that's more controversial than I thought. I think if it's a very straightforward case where you've got two experts who've gone down this route a number of times before, you don't need to, otherwise I would. But actually, I think, José Maria, you're a better person to answer that question than I am, because you're the expert. Do you find an agenda helpful or not?
I think it is, and depending obviously on the case, but I think it helps us to sometimes to focus on the points in dispute, and what is very useful as well is, if we are talking about quantum, just perhaps having the different calculations made by the experts, and well, but Chris is as always right when saying agendas are usually impossible to agree with the other party. Well, that's difficult, but sometimes Chris, hello Chris, sometimes in my experiences, it is easier for the experts to set up the agenda. We are a very limited legal expert community in this country, at least, and believe me or not, but we're getting very well. And for us, it's not difficult to say, well, these are the points that we are going to discuss, and this could not create any difficulty. Sometimes it's better just try for the expert to not to agree, but just to see. Sarah Prager says, "Leave it to the expert." Yeah, leave it to the expert. That's the summary if I wanted to say. But obviously obviously sometimes it's very difficult to get that agenda. But if possible, and especially in those cases where, or in those reports dealing totally or partially with quantum, I think that an agenda facilitates discussions. In my opinion, that's my opinion.
Sure. Yeah, and I think you should have some input into the discussion and talk to your expert. This is a good time for a conference where, you know, before the joint discussion, you need to be talking to your expert. Quite a lot of experts get railroaded at joint discussions, and that's something that you need to guard against by preparing your expert for it. So you need to have a conference with the expert before they have their joint discussion with the other side. Your expert needs to be well prepared. I have had a number of cases where my expert has been basically run over by the other expert in joint discussions. And the reason that's happened is that the other expert has said, I'll prepare the joint reports, I'll take control of this, I'll do the agenda for it, I will run it, I'll ring you, and I will run the joint discussion, and then I'll produce a joint report. All you need to do is just sign the bottom of it. And my expert has gone, yeah, okay, I'll do that then. And they've come to the joint reports, joint discussion rather, underprepared and lazy, honestly. And this is one of the things that you need to think about when you're instructing an expert as to whether they stand up against the other side's experts. Because if they don't, they're the worst possible type of expert. As we've discussed before, they're the kind of expert who gives you a good report, good, solid, nice report that seems to support your case, and then crumbles at either at the joint discussion phase or at the cross-examination phase. So make sure that's not going to happen. Prepare them in conference. Make sure they're prepared for the discussion. Get your barrister to play devil's advocate, pretend to be the other expert and say, well, hang on, I'm right on side because of X, Y, and Z. What about this case in the Spanish courts? What about this medical provision? What about this? What about that? And see if your expert's going to crumble. Prepare them. You're not coaching them, but you're preparing them to be challenged on their opinion and be prepared to stand up and defend their opinion, because that's something they ought to be able to do if they're a competent expert. Now that feeds in, of course, with preparing your expert for trial. A conference with all the experts is really helpful, because sometimes you will have, quite often you'll have cases with a number of experts whose evidence overlaps, for example, and who feed into each other. They all need to know what the others are saying. That means that the experts need to have bundles which contain all the reports of everyone. So not only your own reports, but the other side's reports as well, and the scientific literature. And not only do they need to have those bundles, they need to have read them. So you need to give them the time to do that and the money to do that, the hours to do it, and to hear the evidence of other witnesses as well. So it really helps if your expert has heard all the lay witnesses and is there then to hear the other side's witness, expert or lay, and will then be able to say, well, I've heard what everyone said in this trial, and either it's changed my mind a little bit, or it hasn't changed my mind at all, or it's just made me more sure that I'm right. But they've got a great advantage. Sometimes I've had cases where my solicitors have parachuted an expert in on day 4 or 5, and the other side's experts have been there all the way through. It's hopeless. It's a real false economy, because your expert has no idea what was said, whereas the other side's experts do know what was said. And so the judge is more inclined to go with their opinion because they know what's going on, unlike yours. And lastly, the use of props. This is something that somebody in Chambers suggested. And I think actually we might be a slightly theatrical Chambers, because someone else in Chambers was saying, you know, get them to bring x-rays and x-ray machines, get them to bring skeletons so they can point out the various bones. I once had a case where I had someone, my client, had been rendered partially deaf because someone let off an air horn right next to his ear. So of course I had to bring an air horn to court and let it off in court. I actually slightly regret doing that now. But yeah, no, props are great. So there's nothing wrong with the use of props by an expert, but just get the expert prepared and in a mindset for fun. They should be confident when they go into trial, and they can only be confident if they know that you're behind them and they know what to expect from trial. They shouldn't be going in with no idea what the setup is.
That's very, very important, Sarah. I think I told you last week. I explained you my first trial as expert. Here in Spain, when you have experts and they need to be in court, they are not allowed to listen what the other party says. They are just convoked to a specific date at a specific hour, and then they are cross-examined, and then they can go. So that was my mentality, and the trial was a 3 days trial. I think it was, I don't know, I don't remember where it was. So I asked my instructing solicitor, well, this is Monday, Tuesday, Wednesday, when I should be there. I mean, Monday, Tuesday, no, you should be there Monday, Tuesday, Wednesday. And I didn't know that. And obviously it wasn't a big issue, but I think sometimes we as instructing solicitors or instructing barrister, we need to explain our expert all the liturgy around the trial. They will probably know, but what happened in those cases where you need to choose the younger option or you decide to choose a young solicitor or a young expert. You need to try to diminish the level of stress of a solicitor in court, in a foreign court. So I think we have been discussing of this. Just my recommendation for barristers and for solicitors is perhaps to prepare a kit or a frequent ask questions for experts, not just for solicitors, perhaps for even more probably for technicians. I mean, a lawyer at the end of the day is a lawyer, and it has been in a courtroom several times before. But imagine a doctor or a foreign doctor, or imagine an architect. He needs to know how to behave. He needs to know, you know, we have something similar here for criminal cases where when we represent accused party, like don't look at me if the judge is asking you. Be polite with the judge. You will be asked first by the judge and then by the parties. These type of things creates or decrease the level of stress of the professional, and it is and redounds in the benefit of the client and of the outcome of the case. So this type of guides for experts are very useful, and it takes 1 hour to prepare and can be used several times.
I think that's an absolutely brilliant tip. I mean, just really, really good. I think if you take one thing away from this, that's such a great tip, because, and that for lay witnesses as well, you know, for everyone, it's an unfamiliar surrounding, and it does no harm just to have a bit of paper that tells you what to expect. You get it in conference, because the barrister should be doing that in conference as well, but just something written down that they can take away, refresh their memory, and not in conference where it's a bit overwhelming. I just wish we had that. Yeah, I've never seen that before, but I'm absolutely going to do it now. I think that's a great tip. Thank you. Now, my last slide, well, not my last slide, but a quote from Laura Johnson in Chambers, who some of you may know does clinical negligence and PI work. Experts are like bungee cords. You can stretch them so far, but they always snap back, either in the joint statement or even worse in the witness box. By which she means you can persuade your expert to say something. You might even be able to persuade them to support your case when they don't really, but at some point they'll snap back to what they really believe. So what you need from your experts from the beginning is for them to give you the evidence that they really believe in, the report that they genuinely stand behind. And then we had a number of questions, lastly, that we were asked a little later. Is it permissible for a former employee of a party to act as an expert for or against that party? It's permissible, but it's not a great idea because they're going to get shredded. Whether they're acting for or against that party, there'll always be cross-examination where the barrister is going to absolutely rip them apart because it's very, very hard for them to be unbiased. Managing a difference in strategy, what if the expert thinks that one argument is stronger than another and you disagree? Well, I think Jose Maria's anecdote actually there is a little bit humbling because sometimes your expert's going to be right. So if your expert thinks that there is a strong argument, don't just say, well, you're just the expert, I'm the strategist here. Take it on board. Your expert is part of your team. That is part of the reason that we instruct them, because they do have an input. They may have an idea that actually saves your case, as in Jose Maria's jurisdictional question. So if your expert thinks that an argument is stronger than another, they might be right. Consider whether they're right. If they are right, then your strategy changes and you move with theirs. If they're not right, discuss it with them. Explain to them why you don't agree with them and try to reach some kind of consensus. You don't have to agree about strategy because actually you are the person in charge of strategy at the end of the day. But if your expert has a very strong view about something, let them have that view. They are the expert. They do know more than you do about this particular issue. And then lastly, a Darius question, I'm happy to say, nautical assessors in the Admiralty Court, anachronism or the future. This is, as some of you will know who work in the Admiralty Courts, where you have certain particular types of Admiralty cases. So for example, collision cases, you will have a judge sitting with an assessor who is an independent party. And it's kind of a hybrid system where it's adversarial and inquisitorial. So it's an English / crossed with Spanish system. So the nautical assessor is an expert themselves, but sitting and assisting a judge. And that's something that is enshrined in the Admiralty rules. So the claimant pays for that, or the claimant undertakes to pay for that before they start with those particular types of cases, like, as I say, collision cases. Now, this is viewed as being a really good thing because it means that the expert can make a judgment, an informed judgment, an unbiased judgment about why, for example, the collision happened. It's a move towards an inquisitorial system like they have in the European civil courts, so civil code courts. So I'm not sure it is an anachronism, actually. I regret to say I think it might be the future. I'm a really firm believer in the adversarial system. But I actually think because it's going to be cheaper and it makes a lot of sense to do it that way, to have an expert sitting as a judge. I don't know, this is really a question that goes, the answer to which depends on whether you believe in an adversarial or an inquisitorial system. What do you think, Jose Maria? Experts as judges, good thing, bad idea?
Well, it's a very good question. Well, in fact, this is something that you already have in a way where some lawyers or some barristers become a district judge, and they are expert on procedural law. Here in Spain, we have something similar, where some solicitors can opt to be judges in certain circumstances. I think having specialized courts and having specialized judges is good for everyone. What is difficult is a district judge dealing with a foreign case and then dealing with a local accident and then dealing with a dispute between neighbors. That's very difficult. But perhaps having a panel of expert judges to deal with certain areas of the law, like for example international law or foreign law, generally speaking, or I don't know, aviation, transport law, which is a very specific side of the law. That I think that's not a bad idea. Why not?
Well, who knows? Maybe you're going to be a judge in our jurisdiction soon.
Well, that could be a very, very bad news, and that will confirm that things are going bad after Brexit. So,
well, I got to say, I think that would be a great idea, actually. I think we've come up with some brilliant ideas today. We've overrun a little bit, but if you have any questions, any observations you would like to make, then please do. We've tried to answer all your questions, so let us know if we haven't achieved that. But otherwise, I think on that note, and on the note that I'm hoping that one day I'm going to be appearing in front of José María, and he's going to be answering all my queries about Spanish law. I'm hoping that's the future. Otherwise, it just remains for me to say that next time, 13th of October, it's Ella Davis and Dom Smith, and they will be talking about beauty treatments. And when I first saw this, I thought that we'd gone mad and that we were going to start giving recommendations for Botox, but apparently this is to do with claims arising out of beauty treatments. So I think things like Botox, plastic surgery and that kind of stuff. But tune in on Wednesday 13th to find out. So thank you so much, José María. That has been really, really helpful. I'm going to go away now, and I'm going to do a list of tips for experts on how to give evidence in the English courts and what to expect. I think that is just a brilliant idea.
Thank you, Sarah, for the invitation. It's been, as always, a real pleasure talking to you. And as you have said, I hope to be on the same side rather sooner than later. Let's see. Let's see. But meanwhile, thank you for confirming that you can be competitors but friends.
Oh,
that you
absolutely.
can have this type of conversations in a healthy way. Thank you very much for all the attendees, and have a good lunch to everyone, by the way.
Yes, thank you, everyone. Thank you all. And thank you, José María, so much. That was great.
Thank you so much. Take care. Bye-bye.
Thank you.